Welcome. My name is Attorney Peter Angelis from the law offices of Alexander and Angelis PC. I lost the coin flip about 30 years ago. By way of background, I'm a licensed attorney practicing in the state of Michigan and also licensed in the state of Ohio. My practice emphasis is auto negligence, motor carrier defense, insurance defense litigation. And today I'd like to present to you a short presentation regarding Michigan no-fault, first-party claims. Unfortunately, accidents happen. If there are no motor vehicle accidents, there'd be no auto insurance, there'd be no claims adjusters, and there'd be no insurance defense attorneys. And then it's up to the insurance professionals, the claim professionals, to investigate how accidents happened, what injuries occurred, what the liabilities of the respective parties are, what the insurance coverages are, who is in the order of priority to pay those coverages, and how best to efficiently and fairly adjust claims. And then the investigation begins. Each of you working for insurance companies has your own standard operating procedure that you have to follow. Generally, that includes obtaining the statement of your insured, obtaining a copy of the police report, obtaining the medical records, determining the severity of the accident, and then administering the claim. So that's the who, how, when, why. Michigan no fault refers to the obligation to pay PIP benefits without regard to fault. And when we're talking about first party benefits, we're generally discussing the economic losses. Economic losses arising from a motor vehicle accident are payable by the no fault insurer without regard to fault. These first party no fault benefits are often sometimes referred to as PIP benefits. So I will be using those terms interchangeably, PIP benefits or first party no fault benefits. First party no fault benefits or PIP benefits are generally 3 years of wage loss from the date of the accident, 3 years of replacement services, and medical coverage depending on the coverages selected by the insured. Those benefits paid under the no fault statute are non-subrogable. The initial and primary responsibility of an insurance adjuster or claims handler is, of course, to determine whether any coverage exists. Generally, coverage exists to the named insured and any insureds by definition. There is also a statutory obligation to provide insurance to a resident relative or a spouse living with a named insured. So again, the named insured is provided with no fault coverage. The spouse of the named insured who is domiciled with the named insured is entitled to be provided with no fault coverage, and any relatives living with the named insured are entitled to coverage from that insurance company. This is all assuming that the non-named claimants do not have their own no fault benefits. By far the biggest exposure to a no-fault insurer is the medical benefits which may be owed to an insured. Up until recently, the state of Michigan had an unlimited medical benefit coverage on all policies. Recently, the law has changed. Michigan underwent a significant no-fault reform about a year ago in 2020, and that permits insureds to elect coverages between $50,000 and unlimited. The levels of coverages are $50,000, $250,000, $500,000, or unlimited. Under very limited circumstances, a person can waive all medical coverage altogether if he or she is receiving Medicare or Medicaid or some state assistance. However, generally you're going to be dealing with people that have selected some level of coverage. So right after you decide whether an insured or claimant is entitled to coverage, either because of the policy or because of the facts that the individual is a resident domiciled with your named insured, your next step will be to determine what level of medical benefits were selected by your insured. How much coverage for medical benefits does your policy provide? Now, if the policy provides for unlimited medical, there's another bit of good news here. Michigan has a Catastrophic Claims Association, also referred to as the MCCA, and after the claim reaches $580,000 in the aggregate, in other words, if you have two or more claimants that exceed $580,000 arising from the same claim, the claim goes to the Michigan Catastrophic Claims Association for reimbursement. The original insurance company still has to administer the claim, but then the original insurance company can submit for reimbursement from the Michigan Catastrophic Claims Association. There's a process to do that, and I'm sure many of your insurance companies have contacts with the MCCA, and whenever there's an identification of a claim that could become a CAT claim, a catastrophic claim, you need to notify the MCCA and fill out all the proper forms so that they're aware of the potential claim exceeding the retentions of your firm. The other thing to know is that, as with all no-fault benefits that are paid, they are non-subrogable under most circumstances. Some other changes with the No-Fault Act here in the state of Michigan that are going to go into effect in 2021 is the fact that family-provided attendant care is being limited to 56 hours. If it's going to be agency provided or non-family provided attendant care, there's still no limit on the number of hours per week. Also, Michigan has adopted a fee schedule, which is very good news, because in the past, part of our litigation was over what a reasonable fee was, but fortunately for, I believe, everyone involved, beginning July 1st, 2021, the state has adopted a fee schedule, and that fee schedule is pegged to the Medicare reimbursement rates. The next benefit which a claimant may be entitled to is what's known as replacement services. Replacement services are $20 per day for up to 3 years. The claim for replacement services should be supported by a doctor's prescription. Replacement services is something different than attendant care. Replacement services are usually household chores, lawn chores, things of that nature. Next, we have no-fault wage loss benefits. Again, no-fault wage benefits could be payable up to 3 years after a loss. A claim for no-fault wage loss benefits should be supported by a medical opinion and a medical disability slip. Once the insurance company claims representative obtains that information, the insurance company will take steps to verify the wages. There is no exact formula to determine the average monthly wages, like in workers' comp. Here in Michigan workers' comp, you take the highest 39 of the previous 52 weeks. But in the no-fault context, it's just important that each insurance company develop its own criteria for determining the average monthly wages. Once you determine the average monthly wage, the rate payable for no fault is 85% of the gross wages, and that is for 3 years. If an individual is only temporarily unemployed or in between jobs, it is possible that a wage benefit might still be due and owing. Further, you should know that there's a statutory maximum payment. Currently, the statutory maximum payment is $5,755 per month. That increases slightly each year. So let's turn our attention a little bit to best practices in handling these no-fault claims. When the no-fault claims come in, you'll for sure initially want to determine whether coverage exists. Are we dealing with your named insured? Are we dealing with a resident relative? Are we living with a spouse that's domiciled with your named insured? Next thing you'll want to do is determine the level of coverage that was elected by the insured. Remember, now in Michigan, insureds can elect coverages between $50,000 to unlimited in terms of medical. You're always going to have 3 years of wage loss, and you're always going to have 3 years of replacement services at $20 a day. Then after that, you'll take a recorded interview or have your insured submit an application for no-fault benefits, providing the location of the accident, date of the accident, nature of the injuries. Once you get the nature of the injuries, you'll also want to make sure that there has been an accident that occurred, so you obtain the police report. you'll obtain the medical authorizations from your insured and then go ahead and subpoena, or actually this will be pre-suit, so there'll be no subpoenas, but you'll actually go and request the medical records from the providers, and then you'll want to match up the alleged injuries with the motor vehicle accident. Benefits are only owed if the injuries arose from the operation of a motor vehicle being used as a motor vehicle. So if the motor vehicle was parked and the person had completed a lighting or getting out of the motor vehicle and slipped and fell on ice, that is not a no-fault claim. Then you'll want to make a determination. Is the medical reasonable? Is it necessary? Is it related to the accident? You can get a feel for that, or many insurance companies have registered nurses that will review claims to determine how long a person should be treating for a specific type of injury. Then you'll instruct the insured to submit medical bills to the carrier along with the medical records so that you can match up the services being provided with the motor vehicle accident. Sometimes those medical bills can come directly from the provider. The medical bills, as with all no-fault benefits, can be submitted by the providers. They don't necessarily have to be submitted by your insured. The claims handler is going to want to verify the wage loss, so you'll have to obtain the employer information from your claimant. It becomes more difficult if your claimant is a self-employed individual. You'll have to ask your claimant to provide either tax records or some proof of employment and wages. You'll have to determine whether the replacement services are prescribed. You'll have to find out who is providing those replacement services. All insurance companies have a log for replacement services, and those are payable at $20 per day. You'll have to determine whether the attendant care is being prescribed and whether the attendant care is appropriate and the number of hours of attendant care being provided. Keep in mind to determine whether the attendant care is being provided by a family member or a non-related individual or agency, because family member attendant care is capped at 56 hours per week starting this year, July 1st of 2021. Then you also want to consider whether your claimant was in the course and scope of his or her employment at the time of the accident, because if he or she was in the course and scope of employment, the primary provider of medical wage loss is the employer. It's a workers' comp claim. However, where the workers' comp insurance company contests its liability, the common law or our case law indicates that the no-fault carrier has to step up and administer and pay the no-fault claim and then seek reimbursement from the workers' comp carrier by filing a workers' compensation action. Even if the workers' comp carrier has stepped up and is paying wage loss, there will be a slight wage loss differential. The wage loss benefit in the no-fault PIP context is 85% of gross, and the workers' comp wage loss claim is 80% of the after-tax average weekly wage, which works out to be about 67% of the gross. So there's usually about an 18% to 20% differential between what comp pays and what the no-fault carrier pays. So even if the workers' comp steps up and is paying wage loss, you may be faced with the claim for the wage loss differential between the comp rate and the no-fault wage loss rate. So when do these benefits become due and payable? First of all, the insurance company is not under any obligation to go soliciting claims. The insured has the obligation to present a claim to the insurance company for no-fault benefits. And in fact, the statute states that the no-fault benefits do not become due and owing until 30 days after the insurance company has received reasonable proof of the claim and also reasonable proof of the amount owed. So the insurance company is entitled to receive the medical bill detailing the procedure codes along with the supporting medical documentation. Once that information is received, the insurance company has 30 days to pay that claim. Now let's say the insurance company is presented with medical claims from 5 different providers, but only 3 of the providers provided the reasonable proof of the claim and the amount owed. That doesn't mean you cannot pay all 5 claims. The insurance company is obligated to pay the 3 claims that were reasonably proven with the amount owed, and everything looks good on those 3 claims. You have 30 days to pay. On the 2 claims that were not properly submitted, because there's some question as to whether the services rendered related to the accident or no amount was provided, then you should carefully document your claims file that that information was not provided, and make sure your insured or the provider understands that they're obligated to provide additional information. You want to document your claim for anything that has been submitted that you decide not to pay. And if there's a reason for you not paying it, that has to be documented. You should send a letter to the provider or to the insured, either by email or regular mail, that we would like to see the supporting medical records with these charges. And then once we receive those, we'll administer the claim. Now, under our new statute, these deadlines are extended a little bit. The insurance company is given an extra 60 days if the allowable expense is submitted more than 90 days after the services are rendered. And so that might come into play as well. Now, there is a detriment to the insurance company not paying after reasonable proof is submitted, and that is the statute provides for attorney fees and penalty interest of 12% should a case have to be litigated. So it's very important for the claims representative to document the claims coming in, document what claims are being paid, and to properly document why certain claims are not being paid. If there's some deficiency in the proof submitted, that has to be documented, and you should send some communication to the provider or to the insured, or both, indicating that the information is defective and what additional information is needed. There are also limitations of time, or statute of limitations, for making claims under the No Fault Act. A action or a lawsuit for the recovery of unpaid no-fault benefits must occur within 1 year after a motor vehicle accident. Now, if notice has been given of a claim or payment has been made, the insured has, or the claimant has, 1 year from the last allowable expense. Also, if there is a lawsuit filed, we have a 1-year back rule. So whenever the lawsuit is filed, that lawsuit can only go back 1 year and claim no-fault benefits 1 year back from the date that the lawsuit is filed. Finally, the changes to our no-fault statute have created a tolling provision extending the statute of limitations during the date a claim was made and the date of a formal denial. So it's important for you to receive claims, and if for some reason the insurance company, your employer, decides to deny the claim, you should have a written denial of the claim in your file and sent out to the claimant, because that starts the ticking of the 1-year statute of limitations. I hope this discussion was of some benefit to you. This was intended just to give you a broad overview of Michigan's no-fault claims from a first-party perspective. If you have any specific questions or have any legal needs here in the state of Michigan, please consider our law firm. Again, the firm is Alexander & Angeles PC, and we cover cases throughout the state of Michigan and in the state of Ohio. Thank you.